And let me now introduce our last speaker, who comes from academics. And his name is Dara Hallinan, and he is a legal academic working at the Institute for Information Infrastructure in Germany. The interesting thing that Dara has a legal background, and his academic research is focusing on interaction between law, new technologies, and society. Moreover, he is an author of a recent book, Protecting the Genetic Privacy in Biobanking Through Data Protection Law. In his presentation today, Dara promised to provide us an insight into the strange and fascinating questions which emerge when we speak about genetic data meets data protection requirements. Great to have you here with us, Dara. Stage is yours.
Thank you very much. I will try to fulfill my promise. Okay, so there we go. So genetic data is a really unusual type of data. It relates to individuals in unusual ways. It relates to potentially more than one individual at any given time, potentially even to groups of individuals. And it's used in peculiar processing contexts, genomic research, straight to genomic or straight to consumer genetic testing. It's kind of a very unusual contexts. So when you try to deal with such an unusual type of data displaying these unusual characteristics in relation to data protection law, lots of very unusual, very strange questions appear. And I'm just going to discuss two of these questions today to try and give you all a taste of this odd world that I find so fascinating, and maybe with that entice you to go a little bit deeper yourselves. So the first question is, how should biological samples be considered under data protection law? So genetic data often starts life in a biological sample, and essentially wherever the sample moves, wherever the sample is stored, the data contained therein move and are stored in the same place. In this regard, the sample can be considered as functioning as something like a data carrier. So imagine it as akin to a USB stick or a computer hard disk. But if the sample can be regarded as a carrier of data, the question then obviously arises, should data protection law apply in relation to the sample? When you start asking that question, a world of peculiar sub-questions and lines of thought appears. So in the first instance, the question arises as to whether whatever it is that we're conceiving as data in the sample, let's say DNA for argument's sake, can actually be thought of in terms of information, as the term is used in the law. So data protection law only applies when personal data is processed. And according to the law, personal data can only be regarded to exist in relation to some phenomena in the world, where this phenomena can be regarded in terms of information. Now, superficially, it seems that we should be able to answer that question very simply. We talk about information all the time in data protection law: information, information processing, information storage, etc., information. But as you look a little bit deeper, the situation becomes considerably more complex and unclear. You look at the law, we have scarcely any definition for this concept. It's very difficult to find useful sources in legislative materials or in jurisprudence or any authoritative guidance. What you find is like these very vague and not particularly useful statements like information means any information. Wonderful. And then you might look outside the law, outside data protection, to see if perhaps information has been defined in other areas and maybe if these can provide some inspiration. And when you do that, you disappear down an enormous rabbit hole. And I know there were some computer science speakers speaking earlier, and I'm sure they've just rolled their eyes. You find concepts of information appearing in so many different disciplines and all defined in different ways, depending on the function they aim to perform in that discipline. So maths, in psychology, in sociology, in computer science, in biology, in physics, all of them different. It's a confusing question, and it seems like it should be so easy to answer. Anyway, if we simply accept that samples can be the subject of data protection. If we skip over all this conceptual awkwardness, we face another question. Can we then just apply the substantive provisions of data protection law as we apply them in relation to other information storage and transfer media? And actually what you find is the answer is no, or not at least without further consideration. So certain provisions appear to lose a little bit of meaning or become a little bit awkward to apply. So things like data minimization, accuracy, they're not relevant in the same way as they are in relation to other forms of data or other forms of media. Other provisions actively produce peculiar side effects. So for example, the right to obtain a copy of one's own personal data. When you apply that to biological samples, you impose really heavy requirements on data controllers that don't appear in relation to any other transfer medium and require considerable thought as to whether we really want to do that, want to impose these obligations on data controllers. And if we do, whether we want to impose them in all contexts. So for example, if a data subject exercises their right as entitled to a copy of their biological sample, technically, the data controller is put in the awkward position that they either have to sequence the sample, produce an electronic copy of the genomic information contained, and then transfer that to the data subject at considerable cost, or they have to actively copy the biological sample, which is possible, but also at considerable cost, and then transfer the copy to the data subject. Again, expensive, time-consuming, resource-consuming in a way that other medium aren't, and arguably useless in most contexts to the data subject. So I move to the second question. Can genetic groups be protected under data protection law? So genetic data can be analyzed to reveal insights about the genetic groups to which an individual belongs. So essentially, the other individuals with which the source individual shares some genetic code, whether that's via inherited links or some other form of sort of horizontal link. And in certain cases, genetic groups can be regarded as subjects with rights to be protected. And this raises the question, could data protection law function as a source of protection for these rights? And again, when you start asking this question, a world of very peculiar sub-questions and odd lines of thought appear. In the first instance, come up against this question as to whether data protection should even have anything to do with groups and the protection of groups at all. On the one hand, if you look at the framework that we have in Europe at the moment, look at the GDPR, it's very clear that it's been designed for individuals. On the other hand, if you look at the history and context of data protection law, you see that groups have indeed played a role throughout the history up to the GDPR in data protection. So Convention 108 mentions them. There were certain national data protection laws under 9546 that actually provided protection for certain forms of groups. And if we take the idea of protecting groups seriously, data protection does seem like a kind of a logical home for their protection. It is, after all, the area of law that we look to provide protection in relation to the risks posed to rights in information processing. So if we skip all this conceptual awkwardness again and move on, and just accept that the proposition that data protection might provide a logical home for the protection of groups, we come up against another question, and that's, can we consider genetic groups as data subjects and then just apply the provisions of law as usual? Unfortunately, again, the situation becomes very complicated. The first issue that arises is you have to decide which genetic groups you actually want to protect. Essentially, each individual belongs to an essentially unlimited number of genetic groups. And it's ridiculous that you would think that all of them should be protected in relation to every single set of genetic data. But this requires you then to draw a line between those groups which should be protected and those groups which don't deserve protection. And we can draw that line, but drawing that line requires some careful thought because you're excluding potential subjects of protection. So once you've drawn that line, you say, okay, let's move on. We know who we're protecting and who we're not. Can we then apply the provisions as they appear in data protection law to these new subjects of the law? What would happen if we did? And there again, we find awkward, difficult questions. Fascinating questions, but awkward and difficult questions. And perhaps the biggest issue is what actually would happen if we applied the provisions to all possible data subjects at once. So essentially, the data protection framework as we have it has been designed around one individual and one controller and their relationship. If you throw a whole heap of subsequent data protection or data subjects into this relationship, you create a whole series of conflicts for which the framework was not designed and for which it provides almost no solutions. And you see this really, really obviously in relation to data subject rights. What happens, for example, if in relation to consent, if consent is required for processing? Who does the consent come from? Does it have to come from everybody? One type of data subject, which data subject, why, et cetera, et cetera. What if a data subject wants to withdraw their consent, but the others want to continue with the processing? What happens? It's not that these questions don't have answers, but we don't have answers to those questions in data protection law at the moment. So I hope that provided something of an insight into some of the unusual questions that emerge when we talk about the relationship between genetic data and data protection law. Questions that don't emerge necessarily, or don't emerge so prevalently in relation to other types of data. And I hope that has whetted at least some of your appetites to delve deeper into an area I find completely fascinating. Thank you, and I hope I haven't gone over time, and I hope there's time for some questions.
Thank you, Mr. Dara, for such a great presentation and for being on time. Actually, since we're a little bit delayed of our original schedule, I would like to directly move to our closure remarks, if you let me to do so. So by saying, first of all, dear friends, dear colleagues and dear guests, I would like to firstly thank all the speakers who joined us today, who shared their great knowledge and great insights from different areas and from different angles. Also, I would like to thank our great audience who was patient and who was able to listen in. We managed to cover so broad range of topics, including overall ethical dilemmas in privacy world, also ethical aspect of unsolicited communications. We covered zero-party data and how it's transforming business strategies. Also, tools for zero-party data management. Again, we were able to cover a so interesting topic, AI, the challenges of regulating AI, and why business should take care about ethics and AI, and how it will change privacy game. Big data analytics was yet another topic. And data governance and how to measure enterprise privacy maturity. And finally, genetics and data protection. That was one additional interesting topic. To summarize, the key takeaways, at least for me, is that definitely the privacy world is changing, and we are coming into a new era, and the privacy area is developing so fast with new technologies, new tools, and new solutions. The question is how to use them in a smart and compliant way. And data protection compliance is not anymore enough, but we shall think about such new trends as data ethics and sustainability, and this is not anymore a future. This is already a new reality. So wish you all the best in these turbulent times. Stay safe, and on behalf of organizers of this event, I would like to we are really looking forward to meet you in the next data protection conference. Thank you.